we're going to turn now to national security accountability. And like the last panel that dealt with law enforcement, this topic probably raises at least as many thorny issues between kind of the tension between transparency and democratic accountability and the ability to effectively carry out a public mission in terms of national security. And also the intelligence community probably has suffered as much as law enforcement in terms of loss of public confidence over the last several years from the revelations that have been going on, the sort of nonstop battle and belittlement from the prior administration, and general questions about how well and how effective they are. So I'm looking forward to this discussion. I'll remind you again, if you have questions as we go along, put them in the Q&A function. We'll try to leave time for some questions at the end. You're also welcome to comment and kibitz in the chat as we go along, and most people are following along the chat as well. And with that, I'm going to turn it over to our incredible moderator, Jameel Jaffer, who probably most of you know as the Executive Director of the Knight Institute at Columbia University. Before that, he was with the ACLU until August 2016, where he was the Deputy Legal Director and oversaw the organization's work on free speech and privacy, as well as technology, national security, and related issues. I'll remind you again, lengthy bios are available on the website, and the link is there in your agenda. So we're going to try to keep the introduction short, and I'm going to just turn it over to Jameel without further ado.
All right, thank you, Dave. And hi, everybody. Great to see all of you, and welcome to our panel on national security accountability. We have a really super set of panelists. I'll introduce them very briefly, although they are, I'm sure, already familiar to most of you. Laura Donahue is a professor at Georgetown Law School who has written widely on constitutional law, federal courts, and national security. Heidi Katroser is a professor at the University of Minnesota School of Law, whose scholarship focuses on secrecy, separation of powers, and free speech. Ellen Nakashima is a journalist for the Washington Post, where she covers cybersecurity and intelligence. Ellen and I were on a panel together for the ABA this morning, so I already know she has lots to say on the topics we're going to be talking about this afternoon. Steve Vladek is a professor at UT Austin, the Supreme Court analyst for CNN, and a social media meme, at least since a few days ago. Andrew Weissman is a professor of practice at NYU School of Law. He was lead prosecutor in Bob Mueller's special counsel's office, and before that served in various leadership positions at DOJ and FBI. So thanks to all of you for being here. We're going to forego opening statements and just launch right into a discussion. So I want to start with the prompt that Dave set out for us in the program materials. Justice Stewart famously wrote in the Pentagon Papers case that most of the checks and balances that work in other spheres don't work in the national security sphere. And I'm wondering whether you think the last 20 years have borne that out. Some very prominent commentators have argued that our system is basically working in exactly the way it should be working. Their argument goes something like this. Press and whistleblowers have exposed the most serious abuses like warrantless wiretapping and torture, black sites, out of control watch lists. Congress has asserted its prerogatives with respect to national security surveillance, detention, and military commissions. The courts rejected some of the executive's most dangerous arguments about the scope of presidential power. And the executive branch corrected itself at key moments. The OLC rescinded the torture memos, for example. The Justice Department nixed certain surveillance practices in the infamous showdown in John Ashcroft's hospital room. The Obama administration narrowed the drone campaign in some important respects. So do the past 20 years show that Justice Stewart was wrong? Let me start with Steve.
This is good. So I can say things that will provoke certainly Laura and Heidi and probably Ellen and Andrew to just come after me. So I want to answer, Jameel, that the past 10 years do, but the 10 years before that don't. right? That I actually think we were in the midst of one of the most robust eras of meaningful checks and balances in the national security space in the late 2000s. That is to say, right, so 2006, 7, 8, 9, where I think in direct response to excesses, both real and perceived, and largely spurred on by sensational journalism that exposed any number of scandals on the national security side, we saw very robust pushback from the courts, even if it wasn't as robust, Jameel, as I think you or I would have wanted. Certainly robust relative to historical precedents. We saw congressional intervention and involvement, even if the results of those interventions and involvements were not the statutes I would have written. Right, we saw discourse about sort of structure and separation of powers in ways that I thought was incredibly healthy, even if the answers weren't the ones I would have chosen. Not ideal, right? I think that we were constantly, I mean, Jameel and I think, have spent the last 15 years fighting with each other about what's the ideal. But that, sort of more robust than any period perhaps other than the late 1970s. And what I find sobering and depressing is that I think we've only been backsliding. And we've been backsliding fairly consistently, I think, for the last 7 or 8 years. I think it actually started in the Obama administration, but accelerated greatly during the Trump administration. And when I look at the courts especially, courts are still routinely doing things in national security spaces that they constantly say they lack the competence to do. I mean, this is one of the great sort of myths. But the Supreme Court has 2 major state secrets cases this term, neither of which I think are going to come out the right way. The Fourth Circuit just threw out the most important challenge to the FISA Amendments Act of 2008, based on what to me is a unconvincing but likely to survive an application of the state secrets privilege. So, Jameel, the congressional intelligence committees have become, I think, subject to partisan capture in ways that really prevent them from serving their oversight function properly. The FISA court, as I know Laura can speak to, and in some respects can't speak to, right, has been, as much a part of the problem as a part of the solution. So I guess I'm of to, like, if the question is the last 20 years, I think it's gone like that. And I think we are now on the downslope. And that,
So
to me, is the hardest part.
I want to let Laura jump in, but I want you to say one more thing, Steve. So if we see this as, in sort of 2 10-year periods, where exactly was the high point here, the accountability high point that you identify? Where would you put that?
I would put it early in the Obama administration, when we were coming off of all of these court decisions, right, that maybe even a little bit later. I mean, Jameel, I think the high point might be different for different issues. So on surveillance, I think the high point might be, the aftermath of the Snowden disclosures and your victory, right, the ACLU's victory in the Clapper case in the Second Circuit. In the sort of national security military detention universe, I would think the high point is Boumediene. Right, and the sort of the litigation after that. So I think that between 2008 and 2012, 2013, there are different high points that sort of demarcate what to me was the outer bounds of how good it got. And then for various reasons that I don't want to belabor now because other people should talk, but that for various reasons, I think we started backing away from that, and that now we're just accelerating to me back down the hill.
Laura, do you want to jump in?
Yeah, sure. So Steve, where do I start with that? Where do I start? All right. So the last 10 years have been better in some sense, and there was a high point somewhere in the middle there. It's just really hard to get on board with that if you actually look at what's come out. So the Foreign Intelligence Surveillance Court opinions, prior to the Snowden documents, there were only 6 in the public domain. Since then, there have been almost 100 released. So I have a foreign intelligence database. I put all of the redacted, declassified opinions up. More importantly, the orders, there was only 1 prior to that time. We now have almost 300 orders in the public domain. Plus we have all of the various procedural documents. And what we've discovered from these publicly available cases is actually that the executive branch has not had fidelity to the law. They haven't had fidelity to the processes that have been put into place. In fact, they haven't had fidelity even to judicial discretion. So when the court tells them to do something, they're not doing it. And let me give you just a few examples from the last 10 years, including the high point, right, that you're citing here. So, the concept of reasonable grounds that information is only to be collected that's relevant to an authorized investigation. So Section 215, under the Obama administration, until the Snowden documents came out, they were collecting information on Section 215. Now that interpretation of the language, a number of courts have now found that that was contrary, that what was being conducted with telephony metadata collection was contrary to the statutory language. So they were interpreting the law secretly in a way that violated the law on its face. Similarly, under Section 702, you can't knowingly collect entirely domestic communications. And yet we find out that in 2011, the court finds out for the first time that the government is knowingly collecting entirely domestic conversations. And it makes the argument to the court, oh, well, but because we're collecting everything, we don't know which ones are entirely domestic at the time, even though we know that tens of thousands of communications that we're collecting are domestic, we're actually meeting the letter of the law. And this kind of formalist legal analysis without actually meeting the spirit of the law and actually interpreting the statutory language in this really extraordinary manner, it's continued. So most recently, perhaps, is the FBI saying that when they're told in 2017 in the FISA Amendments Reauthorization Act that they have to keep a record of every US person query term, and then they come into the FISC with a straight face and say, well, we're actually not going to specify what US person query terms we're using. We're just going to keep a list of all of the terms. And the court tells them, no, that doesn't meet the spirit of the law, it doesn't meet the letter of the law. So they go to the FISCer, and the FISCer says, no, that doesn't meet the statutory language. So kind of the fidelity to statutory language is one problem. Fidelity to processes is another. So we see most recently yesterday, the Horowitz 3, right, dropped yesterday, where we saw not only in the Carter Page applications with the first Horowitz report in 2019 that the attorneys actually in the case doctored.
Laura, you can say something about who Horowitz is, because not everybody will know.
Oh, I'm sorry. So Horowitz is the Inspector General of the Department of Justice, and he looked into Crossfire Hurricane and the investigation into Russian collusion with candidates for office at the time. And in his first report, he's issued 3 of them now. The first one came out in 2019, in which he found multiple misstatements of fact, material omissions. He found that an attorney had actually changed a CIA email to make it look like somebody was guilty of collusion with Russia when in fact he wasn't. And a lot of the information was premised on a dossier written by Christopher Steele, who did opposition research for the election, trying to find evidence of Russian collusion. His second report then came out in March of 2020. And in that report, Michael Horowitz reported, he looked at 29 FISA applications to the FISC, found in every application between 5 and 60 errors, including ones that went to establishing whether an individual was a foreign power or an agent of a foreign power, which the court has to make a probable cause determination for. And based on all of those errors, he did a third report, which came out yesterday. And in that report, he pulled 7,000 applications, which had basically been introduced, I think it was from 2015 until 2020. I have to check the dates on that precisely for the, let's see, Horowitz 3. Yeah, from 2015 to early 2020. And he found, again, persistent problems, 183 cases. They weren't following the Department of Justice was not actually following the Woods procedures, which are a set of procedures to ensure that there is a file supporting any factual information that's made to the court. So I would say that part of the problem is we're still not seeing fidelity to the statutory language. We're still not seeing fidelity to these processes that have been put into place, not only the Woods procedures, but also the querying procedures in 2016. It turned out that the government was not complying with NSA and FBI querying procedures that the court had told them to do. The DOJ regulations and processes in place, I've already given an example. And this kind of institutional lack of candor, if you look at the FISC opinions, they repeatedly go back to this problem with institutional lack of candor. And the last point that I'll bring up in juxtaposition, Steve, to your points, is judicial direction. So there are a number of times where the court has told the government to do things and they're not doing doing it. And the court later finds out that they actually haven't been doing it. So in 2009, the government, it turns out that they hadn't been querying the metadata that had been collected under 215 using reasonable articulable suspicion, although they had been told to do this. In October 16th, October of 2016, it turned out that the government still hadn't been following what the Foreign Intelligence Surveillance Court had told it to do in 2011 that forbade using US identifiers to query upstream data. There were several more compliance issues in 2017 and 2018. When the court directed the government to report non-compliance, the government picked and chose which non-compliance it told the court. It didn't tell the court, for instance, when it forgot to detask selectors or continued to survey people when they were inside the United States. So if you actually look at all of these things together, I really don't see the high point yet. To me, actually, one of the high points is the transparency in that now we're actually able to see more of this with the court's opinions that are now being made available. But I think that the problems are still outstanding and really need to be addressed.
Steve, you want to respond very quickly?
Just really quickly, I mean, I actually don't think Laura and I disagree that much. The question is, what's the baseline, right? That compared to where we were in the 1980s, 1990s, I think there was a robust acceleration of aggressive interbranch checks and balances. Again, not the ones I would have wanted, right? But at least more than we had before. To me, that period between 2006, 7, 8, 9, 10. Laura's right, obviously, that that left a lot to be desired. My point is just that I think that we are retreating even from that.
I want to move on to Ellen, but Steve, I thought you were going to say something different. I thought you were going to say, well, the world we were living in, immediately after 9/11 was one in which the executive branch was arguing that it didn't have to comply with statutory law, that the statutes were totally irrelevant. And now, at least, we're in a world. This is what I thought you were going to say. Not that I necessarily, endorse this point, but now we're in a world in which, at least, we're arguing about whether they are complying with the statute rather than whether they have to. But let's move on. Let's move on. We can come back to this. Ellen, the media since 9/11, Justice Stewart imagined that the media would play this extremely important role, this sort of a preeminent role in holding the executive branch to account for abuses relating to foreign policy and war and national security. Has the media played that role?
So I think, as Steve mentioned, the media has played that role in some pretty significant cases, with blowing the whistle on warrantless wiretapping, on torture, on the sort of figuring out, looking at the targeted killing policies, civilian, killings from drone strikes. A number of cases of stories that happened sort of in that 2006 to 2012, 13, all the way up through Snowden, I guess, time frame. And the question is that how, is that enough? How effective is it? Part of the, I think, issue and challenge we face is that the media landscape is, part of the strength of the media is the fact that we're actually, there are far more of us now in a way than there were, right? In 20 years ago, you didn't have this internet landscape with a lot of different outlets like The Intercept and ProPublica. These days, you do. However, there's also this fragmentation of the media space, and that's made it a little more challenging for, I think, people to key in on some of the main issues. The other, I think, trend that I would point to is that there was, at the same time that the media was disclosing some of these major abuses and issues, there was a concomitant intensification of leak investigations from the executive branch. It coincided with, I think, just this heightened tension between media and the government, which was bred of the fact that we were in this post 9/11 moment. And it was after 9/11, the story was national security, and the focus was much more on the NSA and the CIA and the DoD and these security agencies that hadn't been so front and center before, and we were shining a light on them in a way that, I mean, I know Andrew might want to speak to this a little bit, but that I don't think all of that publicity was welcome from the government. And so consequently, leak investigations intensified. That also tended to chill sources, made our jobs a little more difficult. And I think in the most recent 5, 6, 7 years, we've entered this other new era where the media itself, mainstream media, became a target of the from the executive branch, not just from leak investigations, but we were being cast as, enemies of the people, and that all kind of contributed to making the job of holding the power to account and be serving as another important check on government a little more difficult.
Ellen, I feel a little bit bad asking you this question because your journalism has been so important to exposing government abuses relating to national security. But since you're the representative of the media here, I feel like I need to ask you, what do we do with the fact that so many media organizations celebrated and promoted the expansion of the national security state, promoted the war in Iraq? More recently, I think there's been a lot of criticism of establishment media organizations that some people think were not sufficiently, we're not sort of objective in thinking about the U.S. withdrawal from Afghanistan, and instead sort of almost sort of promoting continued U.S. engagement with Afghanistan. We have so far focused narrowly on this question of, were there instances in which the media exposed significant abuses? And I think the answer to that is clearly yes. But if you have a kind of broader lens on this, the media's role over the last 20 years, I think, is more complicated. Is that fair to say?
Yeah, because I think it is, in the sense that the media are not a monolith. And look, just as there's been a proliferation of outlets, there's been a proliferation of outlets with viewpoint, right? With some that are much more nakedly partisan, far left, far right, everything in between. And when you talk about, for instance, promoting the Iraq War, I mean, the Washington Post editorial board famously wrote an editorial in favor of it back, before we entered Iraq, and then a number of years later actually came back out and did a mea culpa and said we were wrong. But that's the editorial side of the house, and I think most of our audience is sophisticated enough to know there's a difference between the editorial writers and the reporters and the journalists. And I can only speak for people like myself and the Washington Post and the New York Times, who Mark Mazzetti was on this morning. We just try to report the news as fairly and accurately as we can without imposing a value judgment, right, on whether a particular policy is a good one or bad one to take. I think where the press media what we needed to focus on was like more on what were the signs that we were seeing in Afghanistan. What is the likelihood? If we knew that the government, whether it was Trump or Biden, wanted to pull out troops. So what was the likelihood that with a full-on troop pullout, that the Afghan National Security Forces would collapse, and how quickly they would collapse? That's a sort of, factual investigative reporting that we need to do to inform the public, rather than to try to put a value judgment on whether it's a good or bad idea.
Thanks, Ellen. Heidi, I don't want you to necessarily focus solely on this, but Ellen raised the issue of Espionage Act prosecutions briefly, and the role of whistleblowers. I wonder whether you think that whistleblowers have, how important a role they've played over the last 20 years, whether our system, gives as much space to whistleblowers as it should, or maybe too much space. Maybe you can speak to that, and maybe more broadly also to this question of whether our system of checks and balances has operated as it should have since 9/11.
Yeah, no, thank you for that. I think they've played a hugely important role, and I think it's hard to look at that in isolation. So I think you sort of have to see the whole picture. You have to look at that in the context of, what were the conditions that led to the whistleblowing, what followed the whistleblowing, which very much ties into your initial set of questions, Jameel, about, the special nature of the national security space, and have we seen more upsides than downsides the last 20 years? Because I think, the national security whistleblowers, including many who were sources, for some of the terrific stories Ellen did, and that other investigative reporters at the Post, the New York Times, et cetera, did, that, those sort of instances of whistleblowing generally tended to arise out of some kind of failing, right? There was some reason that, the Congressional Intelligence Committee's disclosures to them, didn't do the trick, or other internal disclosures didn't do the trick. And so then we had this whistleblowing, which in a sense, oftentimes led to one of the high points, I think, in the last 20 years, that we can, as Laura was saying, among the high points of the last 20 years, have been instances of transparency. So some of the high points are some of these big stories. But then that was also followed either directly in the case of some stories, or sort of more broadly over time, with this rise of retaliation for blowing the whistle, right? So let me just step back and give a couple of examples, right? So consider, for example, the stories involving, the warrantless whistleblowing program that the New York Times first broke in 2005, right? When that came out, there was sort of this huge firestorm of response. There were congressional hearings. Ultimately, over time, there was responsive legislation, et cetera. As Laura spoke to, there are arguably, it's not so clear that the legislation either did enough, or that it's really in implementation being followed properly. But nonetheless, it led to discussion, it led to attention. That aspect of it was successful. But why did it have to come to that? Well, one of the things that came out in the wake of the story was a lot of discussion on Capitol Hill about whether the administration had actually been informing the Congressional Intelligence Committees the way they're obligated to by statute. And so in the wake of the story breaking, you had finger pointing, you had members of the executive branch saying, well, we told the intelligence committees, and they could have been screaming it from the rooftops if they were worried about it. You had members of the intelligence committee saying, actually, we were bypassed. Either we weren't told anything, or we were bypassed, and the much smaller, more kind of exclusive gang of 8 was informed. So one way or another, it is quite clear in retrospect that the spirit and probably the letter of statutory requirements that the intelligence committees be informed were not followed, right? Now that is not the only thing that led to Thomas Tam and others deciding to make a call to the New York Times. But the fact that those internal sort of by the book channels appeared not to be working were certainly among the things that led to the press, really being sort of the last resort for this information to come out. Then when it came out, I think in many ways that was a huge success story, right? In the way I was just talking about. And we've had other stories like that, right? The Snowden leaks, which were hugely instrumental. Some of the stories about drones, a la Daniel Hale's leaks, et cetera. So that's a part of the success story. But then what else have we seen, of course, as you were asking about, Jameel, as Ellen referred to, in the last 10, 15 years, we've seen a massive rise in prosecution of media sources for revealing classified information. And I'll just step back for one moment for folks in the audience who aren't familiar with sort of the statutory authority on which these prosecutions occur. So real briefly, the Espionage Act of 1917 has these, essentially contains very, very broad language, which I'm oversimplifying quite a bit. But as it's been interpreted over the years, this language is broad enough that it effectively could be read to allow the prosecution of virtually anybody who conveys classified information without official authorization. That could include the press, and it certainly includes individuals who work for the government. Now, until the Obama administration, that had only been utilized 3 times in all of American history. But then Obama began a wave of prosecutions, depending on how you count, 2 or 3 times the number of all such prosecutions of media sources in American history. Trump continued the trend. Not entirely clear where the Biden administration will stand on this, although they have already completed through the sentencing process Daniel Hale's prosecution, which began in the Obama administration. So that's, there's almost like this sandwich. You have this sort of failure of the internal processes to work, followed by the leak, followed by the press doing a fantastic job, a lot of discussion, sort of democratic deliberation, followed by failings in the ultimate legislative response and implementation. And then under this cloud of, massive sort of attack on media sources. So that's obviously, there's a lot more that could be said about that, but I suppose that's a long way of saying it's a somewhat mixed bag.
Thanks, Heidi. Laura, you want to just jump in quickly?
Sure. So just I just want to entirely agree with Heidi about the fallout from Snowden, like whatever you might think about him under the Espionage Act and what he did, over the course of the next year, there were 160 public filings before the FISC. There had been 0 before that. So suddenly everybody was trying to get information, and not just before the FISC, but we saw these FOIA lawsuits that were filed, and we've since seen thousands, tens of thousands of pages of documents coming out of those. We also saw the executive branch, like right away with the review board, it constituted the review board. PCLOB issued its first report, finding the provisions that have been put into place illegal. PPD 28 came, which tried to address our international relationships. And I think to me, the most telling statistic is on the Hill. Congress, the prior year to Snowden, there had been 3 bills considering changes to FISA, and that was a renewal year for the 3 provisions that were expiring. Right after Snowden, there were 42 bills that were considered that year. So it was just kind of an overwhelming response from all branches of government.
Andrew, I was going to ask you a narrower question about checks and balances inside the executive branch. If you want to address that, that's great. But let me ask you the broader question, just about your reaction to what you've heard so far on this panel. I mean, do you have a different opinion about how our system has worked over the last 20 years?
So why don't I just tell you my opinion, and people can judge whether it's different or not. I come at this from somebody who's worked at the Department of Justice, including the FBI, and was there for a number of the things that we've talked about. I definitely share the view on the big picture question that you posed, that you can't validate the system by saying, oh, but look, whistleblowers called it out. That to me is a sign that the system's not working, not that that's, oh, don't worry because whistleblowers will catch the problem or the press will catch the problem. So there's no question that even assuming good faith on the part of people in the government and competence on the part of the government, and I'm not saying, by the way, that either are uniform, like any other place, there's problems with both. But let's assume competence and good faith. There are tons of processes at the department in the national security arena. In fact, when I got to the FBI, I was surprised by just how much the FISA process is overseen, in part because of prior scandals involving national security letters, and just how many people are involved in that production process at the FBI and at the Department of Justice. But to focus clearly on what I think are 2 problems that permeate the national security space, regardless of whether it's a Democratic or Republican administration, is 1, the problem that the national security process in this country is an ex parte process. And that, I think, is a fundamental problem. Not all Western democracies are as ex parte as we are. I think that the amicus process that got us slightly more robust post-Snowden is not anywhere close to what it should be or is in other countries. And that just leads to enormous problems. It is true that in the normal criminal case that things are ex parte, you can get an ex parte Title III, you can get an ex parte search warrant, but those cases go criminal. Not all of them, but you know, and the agents know, and the prosecutors know that you have to be expecting that. Whereas when I was the FBI director, I remember being told that, you know how many FISAs have actually ever been litigated? 0. And that is not a healthy thing, to not have that. And we have, as best as I can tell, a pretty good test case for how that has, you know, in how that has actually played out. I think Laura referred to the 215 program, that's the NSA telephone metadata program. And, you know, as soon as that came out and it was challenged, you know, in a way where there was an adversarial process, it was struck down. Why? Because it was clear that the relevance prong had not been satisfied. But that had been approved, just to be clear, that was not the FBI or DOJ going it alone. It had been approved by 2 administrations, it had been approved by 14 judges in the FISC, and it had been approved and specifically called out to Congress. And this was not anything done, you know, under cloak of, you know, of secrecy within the national security apparatus. It was that there was absolutely nobody on the other side making those arguments. And as soon as that came out, it was actually struck down because the arguments were quite thin. So the second issue that I think, just briefly, that I think permeates the national security space is what I call the 1% problem, and it might even be the 0.1% problem. And that is particularly in this country post 9/11, but it's true in other Western democracies wrestling national security spaces, that the conversation in the national security space is there any chance that this could lead to a terrorist attack? Is there a chance that people will die? And this is a real issue. This is not one where it's easy to say, oh, and to poo-poo the problem, but the problem becomes for the people who are going to argue the privacy side of that equation. There is such a strong counterpoint in those rooms to the problem of, really, are you going to tell the families of the victims that the risk was not strong enough or real enough? One of the things that I found particularly helpful when I was at the FBI was the PCLOB, the Privacy and Civil Liberties Oversight Board, because it gave voice to and strength to the privacy debate and more rigor in terms of how that was going to be evaluated, and people were aware of that. So I think those are what I'm trying to sort of flag as 2 sort of systemic issues within the national security space that are still with us.
Andrew, your first point about how we have a kind of ex parte system is basically a process point. I wonder whether, and I appreciate it, and I'm glad to hear you say that. I wonder whether there's also a substantive problem in that, and this may be just a repackaging of your 1% point, but we don't take into account at crucial junctures the public interest in disclosure, right? And when information is classified in the first instance, rarely is any consideration given to the larger public interest in disclosure. There's instead a narrow inquiry into whether information relates to intelligence sources and methods, for example. Same in the FOIA context. If you go to court and challenge the withholding of some of these materials, the question that will be asked is not whether there's a public interest in disclosure, but rather whether the information is properly classified. And this is the same, and this is, I think, what Heidi was saying when she's talking about the Espionage Act prosecutions. The same is true there, that when we sentence people to long prison terms for disclosing information, we don't consider the public interest in the information they disclose. And I would just love to hear your reaction to that. Is that something that is part of the problem here?
Yeah, I think that is true. I think that's true in the executive, and I think it's true in judicial oversight in terms of the amount of deference. And there's no question that after Snowden, there was more focus on the advantages that can come from public buy-in and public disclosure. But that can be short-lived. And again, I think that one, institutionally, there needs to be a player at the table that has that as part of their agenda. And it's very hard when it's not the P Club and you're dealing with privacy officers. The law is so flimsy. There's no hard and fast rules that it's hard to convey that in a convincing way with the other factors. And I think at the judicial level, I used to teach a class on comparative national security law with somebody who had been on the bench in Israel and in their Justice Department. And one of the things that both of us brought to the table was we both had the view that there was too much judicial deference because both of us had been in the executive and kind of knew what we could call, to put it bluntly, BS. And I think there's a lot of deference and sort of undue deference at times in the judiciary to what the executive is doing and to those kinds of harms and an unwillingness to sort of peel that back in terms of the interest in public disclosure.
Thanks, Andrew. So some of you have already started answering this question, but let me ask you, if we were going to strengthen the checks and balances, sort of strengthen the mechanisms of accountability and access, where would we begin, and what institutions do you think it's most important that we focus on?
Can I dive on that grenade first? So Andrew mentioned a couple of sort of structural weaknesses, and I want to add a third, right, which is how rarely the big legal questions in this field get answered. So Laura's talked a lot about how the FISA court has obviously been a lot busier, been doing a lot more, answering questions not always well, right, in the space. But one of the trends that I think we've really seen, Jameel, as you know well, is the demise of litigation in national security cases. It actually reaches the merits of the national security policy, where the number of sort of procedural or jurisdictional obstacles that courts either conjure or expand or whatever really frustrate merits litigation, where law is not developed, even if whether it's law we agree with or law we don't agree with. Just the boundaries are not set in ways that are ripe for abuse by executive officers who either intend to abuse it or just feel no constraint. So assuming that that's something that is fixable, and I think that much of it is, I would actually think that a really important place to start would be in making it easier for national security policies to be litigated, making it easier for courts to actually rule on the legality of what the government is doing across all of these spheres, and make it easier for those answers, right, to be answers that we may agree or disagree with, but that are answers that form stable rules for Congress to react to, for the public to react to, for government lawyers to react to. Because there's just, one of the things we've seen in Jameel is so much power just attrits to the executive branch in the universe in which there's uncertainty. And so that's, assuming Congress is not going to sort of all of a sudden grow an institutional backbone overnight, I'd at least like to see Congress empower the courts to do so.
I mean, you and I both see this as a big problem, but most of the judges who are throwing these cases out see this as a feature, not a bug.
Right, but I would just say, but the many of these judges at least are responsible enough that they would understand, that their hands are actually that statutes that actually require them to reach the merits of these cases tie their hands. And so, yes, Jameel, they don't want to answer these questions. My point is that I think they can be compelled to in a far higher number of cases. And I think even if I might not like the answers, especially given the structure of the contemporary federal judiciary, I would prefer answers. because I think answers are better than just uncertainty in a universe, especially in this space, where for the reasons Andrew talked about and Heidi talked about, and and Ellen and Laura talked about, uncertainty just enables executive power, it enables secrecy, it enables abuse in ways that answers can't do worse.
Yeah,
Can I-
somebody needs to respond to Alexander Bickel's passive virtues piece. Write something about all the problems with the courts deferring in this context. Sorry, Laura, you were about to jump in.
Oh, I was going to throw out 3 substantive ways in which Andrew and Steve's, suggestions could be put into practice, right? And I'm mindful that there are clinicians and people, watching this that might also have an interest in kind of what can actually be done. And I think if we got rid of these 3 things, we would be in a totally different world. So first is state secrets doctrine, the way that it's been claimed since Jeppesen, right? Since allegations of torture were made and the government came into court and said, oh, we can't possibly you can't possibly let a contractor actually be sued for this because it would reveal state secrets, right? It has since been expanded in a way that is completely inconsistent with how it was for hundreds of years, centuries before the founding, since the founding, right, all the way up to Jeppesen. There's now this assertion being made, which we see in Fazaga, that there's actually a continuum and you can dismiss a suit at the pleading stage. Like that's just kind of a gross overturning of kind of centuries of doctrine of state secrets. So that's the first. And that, the Wikimedia case, the idea that the Fourth Circuit would throw out a Fourth Amendment claim, even once standing is granted. So it means you have no constitutional rights if what you're saying is the government is surveying you. Like that's kind of the bottom line there. So I think state secrets is one of the key ones, which is why all eyes are on the court with both Zubedeya and with Fazaga. The second is Navy versus Egan, this case. So initially the government interpreted that case correctly, but if you look over the last 5 to 7 years, every time they cite that case, they cite it for the proposition that the executive branch can tell the other branches what they can say and what they can't say. And that includes hiding instances of malfeasance, of misuse of law, of secret interpretations of the law. And I think that needs to be put to rest once and for all, that actually Department of Navy versus Egan was just about which agency within the executive branch gave security clearances. It did not give the executive branch a trump over the co-equal branches. There were real separation of powers issues there. And the third I would throw out is derived from. And boy, if MFIA could do something about derived from. So right now you cannot raise an assertion in a criminal case because the government will not declassify what derived from means. So you can't bring constitutional challenges to FISA in criminal cases. And the reason all of these matter is as FISA cases move through the geographic courts, not the specialized FISC and FISCR, that actually we're now seeing more FISA cases in ordinary Article 3 courts than we have seen. And all of these are in that database that I put online. We have more FISA cases in those courts. They cannot move forward because of this derived from. They can't actually challenge the underlying application, which is somewhat extraordinary because Horowitz is finding that there are lies, right? That there are misstatements of fact, that there is contradictory information, and we can't actually get at that in any of these adversarial proceedings. So if this were the holidays and I were to ask for one thing, it would be, or 3 things, I guess, it would be to get rid of these 3 things, because then we could actually reach the merits.
If I could just jump in real quickly, so I completely agree with Laura. If this were, Hanukkah time, I'd ask for this for all 8 nights or what have you. I fully agree with you that these sort of impediments to judicial review do a great deal of damage. That said, right, I'm skeptical. This isn't a reason not to push for it, but I am very skeptical, right, that courts would go in that direction because of how addicted they are to deferring to the executive, which is one thing that does worry me a little bit about, sort of Steve's thought that, the ideal thing is to get answers from the court, right? Even if we don't like the answers, because if the answers are going to be, some really dramatic, broad, sort of assertion of the state secrets privilege and a contention that the state secrets privilege is not only constitutional, but it's exclusive and, Congress can't override it, what have you, we might be better off with some uncertainty. I keep thinking back to, and I think Margaret Quacca mentioned this morning, I mean, the classic example, and this is before I think we even got to the level of judicial deference we've seen in later years. But, you think about EPA versus Mink from the early 1970s, when Congress had basically, gone back to the drawing board to amend FOIA to make it absolutely clear that the exemption one, the classification exemption, was one to which the judiciary did not have to completely defer, that they had to do, kind of their own review to determine if information was properly withheld. And they've pretty much blown past that over the years, right? So there is that worry. And I guess I would tie that though on an optimistic note, because I know part of what we're talking about throughout the day and tomorrow is what can clinics do, right? Clinics as well as other interested practitioners, law professors who might do pro bono work, what have you. I think this actually is a place where certainly litigants, but also amici can play an important role in taking, as Jack Balcom would put it, ideas that are off the wall and partly through repetition, partly through skilled argumentation, kind of putting them on the wall. And part of that, I think, is perhaps increasingly shifting the narrative about the fallacy of the assumption that the judiciary is just not equipped to handle these kinds of things. And that the executive, and I know Steve mentioned that before as well, right? And that the executive alone has the necessary expertise. I know a lot of people have said this to courts over the years. It doesn't always have an effect, but I think that is the kind of thing sometimes through sheer repetition, again, just sort of increasingly sophisticated argument over time, case after case, can be helpful, in the context of national security whistleblowers, for example, a handful of us, members of the Felon Network, actually, so this is kind of a Felon initiative, filed amicus briefs at the sentencing stage in the Terry Albury cases, the Terry Albury and the Daniel Hale cases, to just sort of to kind of put before the court the idea that this notion of an Espionage Act that doesn't take into account the public interest in the information, et cetera, we should stop taking for granted that that's okay. And in the Hale case, we also made the point that, by the way, you've all been relying on this one appellate court case from 1988, U.S. v. Morrison. It's actually awfully flawed, and perhaps we need to start looking at that anew. So anyway, I do think the little note of optimism is that although I'm not wildly optimistic about courts' likelihood to break from these deferential doctrine at the moment, I think now is the time to, well, not to start, lots of people have been doing it, but to continue, sort of pushing and playing the long game.
So why don't I jump in here, piggybacking on Heidi, what you just said about the public interest issue. I agree with you and with Jameel that there ought to be more of an allowance or accommodation, recognition of the value of public interest, whether in to allow for a public interest defense for a defendant in an Espionage Act leak prosecution case. Whether, I don't know how you get that. Is it through amending the Espionage Act or through judicial decisions? But I think that somehow we need to see that, we need to give that concept much more validity and recognition. And I would also like to see that enshrined more in FOIA. Right now, as Jameel knows, there's the executive order that was just issued by Obama, and Trump didn't really touch it, which is probably a good thing. And now, but the Biden administration hasn't revisited it. And I was talking to my colleague and FOIA expert Nate Jones a few days ago in preparation for this panel, and he mentioned, I don't know if you're out there, Nate, but I want to plug this idea from you, that what would be a positive step in the right direction, even though I don't think it's going to solve issues for national security reporting, but for FOIA in general, would be great to amend the EO, which currently says in some exceptional cases, the need to protect information may be outweighed by the public interest. And in those cases, the information should be disclassified. Maybe the Biden White House can replace that language with in any case where the need to protect secrecy is outweighed by the public interest. And in these cases, the information should be declassified. Right? I think that sort of rebalancing of the public interest, versus the need for secrecy might be useful. And then just from a more parochial interest, but also toward the goal of enhancing press freedom, recently the Justice Department Attorney General Merrick Garland issued new media guidelines that, in the wake of these recent controversies over the news that the Trump administration Justice Department had subpoenaed the email and phone records of journalists at the Washington Post, New York Times, and CNN, Merrick Garland has issued new guidance and guidelines that basically say there shall not be, they will not seek compulsory process or subpoena the records of these journalists, either directly or from third parties, which is definitely a step in the right direction. I mean, it's an improvement over what had been, but it is still, those are still just guidelines. And what we'd like to see is, codifying that in law, which would give us more assurance that such actions won't be taken by future Justice Department. And then finally, at a sort of just more cosmic level, I think there is a systemic issue with overclassification in the government and in the intelligence community. I've heard IC officials, I'm sure Andrew would agree, acknowledge that that is a problem. And, I was talking to Sue Gordon the other day. She's the former Deputy Director of National Intelligence, and she was just noting how we have just seen this explosion in open source data, right? So and the IC is actually collecting more of this open source data from companies, from other non-government sources. And that raises the question of whether or not all of this secrecy that's sort of just been inbred in the IC since 1947 is really all that necessary when you are starting to see much more of a reliance, not entirely yet, but more of a reliance on open source data. So I just put it out there as one thought to keep in mind for the intelligence community moving forward, as in terms of maybe it just also needs to rethink the way it collects, gathers, analyzes intelligence, and the degree to which so much secrecy is necessary, if you really want to.
So I want to turn to Andrew, but a couple of things. So first, I think Dave has sort of shown up here again because he wants to remind people that we're going to take questions. So if you have questions, then just please put them in the Q&A. And just one observation before I turn to Andrew, that I think collectively we've identified two kind of almost cultural or attitudinal problems, one in the executive branch relating to secrecy and one in the judiciary relating to deference. And maybe I'm expanding on the points that all of you are making, but it does seem to me that there's something that goes beyond, at least with respect to the judiciary. It's not just about whether judges have the authority to act, it's whether they will use that authority, and that, adjusting there may require something more than just expanding judicial authority. It requires a kind of cultural shift or a attitudinal shift. Anyway, Andrew, if you could improve or change some of these mechanisms, where would you start?
So these are sort of small bore. I'm not going to propose the sort of Bruce Ackerman create a complete independent LLC agency, but it is useful to think about huge big picture issues, and also how to have a more effective Congress, because one thing we haven't talked about is that there's a complete lack, and just a complete application of Congress in the national security space, because it doesn't win. It's just, they realize it's not actually a winning strategy to be taking a stand there. For obviously that's not true for everybody in Congress, but for a vast majority, it's not helpful. But small bore things are, as I mentioned, I think that within the FISC, there has to be a more robust special advocate system. And you can look to Canada, you can look to England. I don't think any system's perfect. It's a hard issue, but the current system, where the court sort of gets to decide if it might be helpful and you don't really have full litigation. Just seems that you don't have the an adversarial process at all, and it is not. The argument I've heard, even when I was in the government, is, oh, so you're saying there should be more process for suspected terrorists than there are for suspected criminals in the normal criminal process. That's not the case. The problem is that in the national security context, it doesn't go to court. So everyone knows there isn't going to be that ability to subject this to the adversarial process. And when I was in the government, my view was like, you know what? If we're wrong after being fully heard, so be it. Like, the court says this is something we can't do, better for us to know it. So I just think that's one thing. And that's something that really is in the control of the FISC. They could just deal with that. The DOJ could deal with it. Congress could deal with it. The second is, as I mentioned, I personally found the Privacy and Civil Liberties Oversight Board a particularly useful mechanism. It doesn't have to be structured exactly that way, but it'd be nice to see them have a much stronger role and seat at the table. And again, that really affects things that we don't see. We've talked about a lot of big picture issues and big legal points, and those are all great and important, but on a day-to-day level, that is going to be where, having them at the table or knowing that they're going to be reviewing matters afterwards is a really useful thing for people in the executive to know. And then the third is, the longer I live, the more I'm really not sure that the FISC was the right mechanism for dealing with national security matters. I mean, there are definitely pluses and reasons for it, but I just think this idea of having temporary judges show up who don't have a lot of experience in national security, and you end up with this huge reliance on staff. I just, again, using the 215 program and the Snowden revelations again about that's the NSA metadata program, that did not speak well for the FISC. There were 14 FISC judges who passed on that. Not a single one had actually written an opinion on that program prior to the Snowden leaks, which itself is shocking. And it just suggests to me that there really does need to be a rethinking about whether that is the proper mechanism for litigating these issues.
That doesn't sound small bore, Andrew. Okay, replace the FISC sounds like a big proposal, although maybe a good one. All right, let me ask you one more question. I know that some of you want to respond to some of the things that have just been said. But let me ask you one more question, then you can either respond to my question or to whatever else you want to. I guess I'm wondering whether you think there's an unusual opportunity right now for progress on one or more of these fronts. And I ask that because Americans' attitudes towards the war on terror seems to have shifted pretty significantly, even just over the last few months. We've withdrawn from Afghanistan. We have a new administration that seems to want to focus on other threats like climate change, for example. Maybe domestic terrorism seems like a more significant threat than foreign terrorism, or at least an equally significant threat. And so for those of us who spend a lot of time and energy worrying about, the health of democracy, maybe there's an opportunity here. I wonder what you think about that. And also, beyond what you've already said, what could we do and what could legal clinics do to take advantage of that opportunity if there is one? You can jump in whatever order you feel like.
I guess I'll try to take a shot. I mean, I'm pessimistic, Jameel, that now is an especially apt moment for anything because of the sort. I'm one who thinks that before you can change the cultures, you've got to change some of the baselines, and changing the baselines requires statutes. And getting anything in the national security space through Congress right now strikes me as an impossibility. I mean, there are, Jameel, there are, amendments being proposed to the NDAA that ought to be completely uncontroversial about limiting when you can use, for example, National Guard troops for law enforcement, where, everything is tribal. And so, I guess I am both I disagree with you, Jameel, about sort of the view that, you have to change the culture in the courts. I actually think that, if you take away yes, there are reasons why judges are going to look for whatever cover they can hide behind, but if you take away all the cover, eventually they're going to have to reach disputes. And so I would prefer, a blue sky regime of accountability where, we're actually telling the relevant officials, telling the relevant policymakers, telling the relevant decision makers that like what you do is going to be subject to meaningful review after the fact. And that's just not the world we live in right now. And I think that has to start with Congress, and I think it's not going to start with Congress, at least this Congress. And that's part of why, I think I'm so sort of down on where we are on the backslide toward the question that you and Dave started us with, like, can you have effective checks and balances in the national security space? I actually believe that the answer is yes, but it requires, I think, different institutional commitments, especially in Congress, than what we're seeing right now.
I guess I'll follow up real quickly. So I'm not as pessimistic as Steve. I'm pretty pessimistic about the opportunity for change right now, particularly in Congress, because I do agree everything is so shoved into sort of a partisan box right now. That said, I also think there are aspects of the moment that may create some unique opportunity. There's, and granted, this will resonate a lot more with Democrats, but certainly among Democrats, there's, still tremendous alarm about abuse of power that crystallized in the Trump years, not to say the abuses, or abuses that some of them, that don't span the partisan spectrum, but Trump was so egregious that creates some momentum. Where I think you may have some bipartisan potential though, and this may be incredibly naive on my part, but I wonder if there may be some bipartisan potential in the general kind of anti-establishment feeling of the moment. I mean, that is one reason why transparency, at least in the abstract, tends to be a political winner. Whistleblower protections, at least in general, tend to be a hard thing politically for Democrats or Republicans to say they're against. So I do wonder if there's some potential, like a door that's cracked a little bit open, where we could seize this moment. And one thing I wrote about in the chat was I gave a shout out to the Protecting Our Democracy Act, which was introduced again. It had been introduced in 2020. It was introduced again, I think last week in the House by Adam Schiff, and it was introduced, I think today, I believe I saw this on Twitter like an hour or two ago, by Amy Klobuchar, who's, not exactly known as a flaming lefty. And she introduced it. There are a lot of really important reforms there, among other things, good cause protections for inspectors general, which could make a really big difference. Enhanced sort of backup for congressional use of the subpoena power. One example of a provision I saw that I really like is sort of harder and faster rules with respect to executive officials claiming privilege when they're subpoenaed, that they have to provide a privilege log. Now, all of this depends on Congress actually having the will to, enforce these things, even if it were somehow to become law. They don't have a great track record there. But I think one respect in which I do very much agree with Steve is that the more you do have clear rules in place, it becomes a little bit harder for members of Congress to wimp out, because it's a little harder for them to say, well, we didn't really know, what were we supposed to do? The information was classified, or they said they're claiming they're holding off in case the president later claims a privilege. What were we supposed to do? If you have in place mechanisms saying, well, this is how you deal with that. They have to claim a privilege. They have to provide a log. It's at least a starting point. So I'm a little optimistic, though I certainly wouldn't be shocked if, there ends up being crushing disappointment in the end.
I think you're right on that, in terms of how, at least on issues of surveillance, for instance, you seem to see some of these strange bedfellows dynamics in Congress. And I mean, like, I think Jim Jordan might support FISA reform, given, all of the issues that have come out with the Carter Page FISA. I mean, think that idea, Andrew, of having an adversarial system in FISA is really smart and terrific and long overdue. And I'm glad to hear you think it can just be done by the court itself. So why not? But I also generally tend to be a little skeptical or pessimistic in that the major reforms of the last 20 years, I think, have all come in the wake of forcing functions, right, of big scandals that have erupted and have then, forced the administration to reckon with it or to account for it when they couldn't just ignore it anymore. Or for instance, just look at Russian interference in the 2016 election. In this case, it was the tech companies, right, that were now all of a sudden on the hot seat. And so you start to see them scrambling to try to reform and clean up their act. I think major changes in direction and policy really only come when people or institutions are forced to deal with them.
So I just want to jump in on the FISC point. So I'm a big fan of adversarial process. I think it's really important. Our system's built on it. And if you have a bunch of people who've been former prosecutors who end up at NSD and are used to another side pushing back on them, I think there's a culture that kind of expects that at some level to actually have somebody pushing back on you. With regard to this bigger proposition, right, which is whether to dissolve because we'd be better off without FISC or FISCR. It's really hard for me to get behind something like that because I see an executive branch that claims it can classify judicial opinions and bury them, that no citizen, even if they can show standing, can bring a Fourth Amendment claim when they've been placed under surveillance because the whole thing is a state secret. When you have an executive branch coming in and not paying attention or actually interpreting the statutory language in this really convoluted way that allows it to go against the spirit of the law, as well as the letter of the law, when you have non-compliance, when you have them ignoring judicial direction, when you have attorneys doctoring emails and putting false information into FISA applications, it doesn't matter how many adversaries are there if the information is false that's being put forward by the government. And I really see this as the more pernicious and concerning issue. On the temporary nature of the judges that are put on FISC, this is to avoid agency capture. With HPSI and CISI, we do see agency capture. We saw, after the information came out from Snowden, Dianne Feinstein, Senator Feinstein went on the road defending the programs, which is how we found out about information being used during criminal prosecutions that actually people who had been tried for crimes didn't know that the information against them had come from FISA in the first place. And when a senator is taking to the road to defend the NSA, I think we're in trouble because the three branches need to be co-equal and set off against each other. That was the design in the Federalist Papers, that's the design in the Constitution. And if they're not upholding their constitutional responsibility, then I think that's really deeply problematic. So in a way, I think we're back to, Heidi, your points, somewhat despairing, I think, of Congress. I think the worst argument I heard was the SCIF was far away. So how was I supposed to read what the intel community was doing? And I just thought, well, because it's your constitutional job, right? Like that's your job description is to oversee that process once you put it in motion. So I guess for me, that if these other elements aren't in place, the idea of dissolving the court that really right now is our line of defense and is the only one that can try to push and inquire into it. I've been pleasantly surprised by how effective the IG reports have been. And I think that really comes down to Michael Horowitz and his integrity in what he's doing there, which is really trying to make the process reflect what they say it reflects, what they say goes into these applications. And I think that's going to go a long way towards building up a better system as well.
Yeah, I'm not accustomed to being the optimist in these kinds of conversations, but it does seem notable to me that there's so much agreement at this point, even among sort of national security officials or former national security officials and civil liberties types, human rights types about some of the problems we've talked about. I mean, overclassification is one. Maybe the FISA court is another. There's a petition pending. The Knight Institute is involved in it. So is the Mafia Clinic at Yale and the ACLU, pending before the Supreme Court right now, seeking or asserting a First Amendment right of access to FISA court opinions. And among the people who are in one way or another associated with the case or amicus briefs in support of the case are, Ted Olson, John Brennan, James Clapper. I mean, you would not have seen this kind of consensus 10 years ago, let alone 15 years ago. And I can't help but be at least a little bit optimistic that the existence of this kind of new consensus around a few of these structural issues might make a difference at the margin. I think that Dave, did you want to ask one follow-up question?
Well, no, this has been a fabulous discussion. I was just going to sort of make a point you were making, the problem of trying to get legislation to do reform. I think that cert petition, at least as one potential answer. I think it's, the point Andrew was making about the lack of pushback, the lack of oversight, the lack of, that you could say the same thing about FISC itself. The fact that 14 judges didn't say anything probably reflects the fact that they knew nobody was going to see these opinions. And what the pending cert petition says is, look, we can't have a court that's totally secret, where we, sure, you can seal documents, but there has to be some independent judicial review. And it shows the classic problem or the breakdown of the separation of powers. The FISC until now says, well, the government classifies stuff, we can't unclassify it. So we just defer to them. Whatever they want to make public, they can make public. We have no independent obligation to do that. That would all change if there was a First Amendment right of access. They would have to independently decide there was a compelling reason to keep these things secret, and that would affect, I think, how they do these things. So maybe there's some change afoot if the court decides to take that case. I'm not totally optimistic, but I have to say this has been a fascinating panel, and I can't say it's been totally uplifting or inspiring, but I appreciate your effort to put a good spin on it, Jameel, at the end there. But I think we've run out of time. What's left is to say thank you to all of you. This has been really helpful and enlightening, and we really appreciate your taking the time. So for the rest of you, we're going to take a quick break. We'll be back at 4 o'clock with another great discussion of libel law as a pro-democracy tool. So join us then.